Thank you for joining us for understanding the RICO indictments against Stop Cop City activists. My name is Susi Durán, she, her, ella. I'm the chair of the Atlanta chapter of the National Lawyers Guild. I joined as a legal worker in 2016 and have been a legal observer since then in Atlanta.
Hi, everyone. I am Sarina, and I am a National Lawyers Guild member in Nashville and also a member of my law school chapter in Jackson, Mississippi. And I recently worked as a NLG Haywood Burns Fellow for Stanley Cohen here. And welcome. Thank you, everybody, for joining. And I will pass it to Suzanne for her introduction.
Thank you, Sarina. Welcome, everyone, and thank you, everyone, for joining. My name is Suzanne Adely, and I'm the current NLG president and one of the co-chairs of the International Committee. This program is a joint effort of the Atlanta chapter, the International Committee, and NLG National. Our program tonight is going to have three main components. The first will be the introduction of the panelists and the moderators. And then we will proceed with the panel on the indictments, and then we'll have a period of question and answer that will be derived from pre-submitted questions that those of you who registered shared with us. I want to give it back to Sarina.
Pass it to Susie now for introductions.
So I'd like to introduce our moderators, both attorneys with local and international legal experience and both active members of our community here in Atlanta. First is Azadeh Shahshahani, based in Atlanta, legal and advocacy director at Project South, former NLG president, and current NLG International Committee member, human rights attorney. In her work, she organizes to protect and defend Black and immigrant Muslim communities from state repression. She provides support to social justice movements in the global South, from Brazil to Palestine. And she writes on topics of US imperialism as well as state repression through counterterrorism programs, surveillance, incarceration, and deportation. And we have Devin Franklin, born in Decatur and still based in the Atlanta area. He's Movement Policy Counsel at the Southern Center for Human Rights. He's previously a public defender in Fulton County for 12 years and is currently a trial advocacy trainer with Gideon's Promise Trial Advocacy Training Program. He and colleagues at the Southern Center for Human Rights have just launched the First Amendment Bridge, which helps protesters criminalized for First Amendment activity find representation in Georgia. And I will pass it to Sarina.
Thank you, Susie, and welcome Azadeh and Devin. And before we get started with our panel program tonight, I would like to introduce you to our panelists who are also attorneys. And I wanted to introduce to you their background so you all can know their unique experience. First, I'd like to welcome Meltzer-Cohen. They are an attorney based in New York, and they are an educator and an abolitionist and a longtime NLG member. Their practice centers around criminal defense, particularly around First Amendment issues and representation of people criminalized for their pursuits of justice struggles. And they also work on advocacy for those seeking gender-affirming care while incarcerated, because this is something that's often overlooked. Some notable cases that Mo has worked on include, but are not limited to, representing Chelsea Manning, working as a staff attorney at the Water Protector Legal Collective in the Standing Rock struggle, and as an attorney during the Occupy Wall Street movement, along with Stanley as well. Welcome, Mo. Then I'd like to introduce Don Samuel. Don Samuel is an attorney based in Georgia, and he has been doing criminal defense practice for over 4 decades and is a partner at Garland, Samuel, and Liu. His areas of practice are vast, and they include in serious felonies, federal charges, and criminal appeals. He's worked on notable cases at the Supreme Court of the United States, including U.S. v. Randolph. And he was lead counsel in a terrorism case in the federal courts of Georgia. And he is currently representing some individuals indicted under the RICO indictment that we will talk about today. Welcome, Don.
Thank you.
And finally, I would like to introduce you to Stanley Cohen. He is also a criminal defense attorney that's been in practice for 4 decades, based in New York, like Mo. And he started as a trial attorney for the New York Legal Aid Society in 1983. And since then, he's been focused on private practice, representing people and groups domestically and internationally that are politically and ideologically accused for their political actions and movements. Stanley was brought up by NLG attorneys that many of us here know of today: William Kunstler, Lennon Weinglass, Lynn Stewart, and Chokwe Lumumba. And some of his notable cases that he's worked on include working in the ICC, representing the Mohawk Warrior Society, the radical Palestinian movement Hamas, which means the Islamic Resistance Movement, anonymous hacktivists, and different people in the Occupy Wall Street movement. Welcome, Stanley.
Thank you.
Yeah, and he is also representing somebody that has been indicted as well. And so with that, as Suzanne was saying before I pass this to our first moderator, again, our panel will be in 2 parts. We'll first look at the indictment and dissect what's going on. And in the second part of our panel, that will be moderated by Azadeh, and we will discuss international law implications and historical and current analogs to this prosecution currently. And so with that, I will pass it to Devin for our first part of the panel.
Good evening, everyone, and thank you so much, Sarina, for that transition and that introduction. So yeah, the first thing that we want to talk to you all about, the first question we're going to have is going to be for Don Samuel. And as we consider breaking down this indictment, case specifically, could you explain the RICO indictment to our audience of lawyers and law students and people of Atlanta, that being the law, the charges, the state's theory, etc.? What needs to be proven?
Thank you, Devin. Georgia RICO is not unlike the federal RICO statute. There are some differences, but for purposes of this indictment, it's not unlike a federal RICO case. A RICO case is essentially a charge brought that requires a few different elements. First of all, there has to be an enterprise. There has to be some group. There has to be some structure to a group. And then there has to be crimes that are committed in order to further the interests of the group. The group is what's known as an enterprise, and the crimes are what are generally referred to as racketeering acts. And it's almost limitless, the type of groups that can form an enterprise. If you just think about the 3 current cases in Atlanta, the big RICO cases we have going on in Atlanta now, and then of course the Atlanta public school system a couple of years ago, APS, the Atlanta public school system, was considered to be an enterprise. And people were committing crimes. The teachers and principals were committing crimes by cheating on the exams so that the students would get promoted. So that's the enterprises, the APS, the racketeering acts was the cheating. And then currently pending in Atlanta, we have the YSL case, which is the gang case involving the rappers Young Thug and Gunna. Began with 28 members of the group, or the gang as they're referred to. And the racketeering acts were far from cheating on exams. It has been alleged, and the case is still ongoing, that there are murders and carjackings and drug dealing and prostitution and all kinds of violent crimes involved with the gang. And then we have the Trump case. And there the enterprise is referred to as the group of people nationwide whose goal was to undercut the legitimacy of the 2020 election and to devise schemes to, in essence, reverse the election results. And again, the enterprise was just a group of people. The crimes being committed in that case allegedly are all kinds of election fraud and lying to the legislature in various states, creating false electoral panels to try to convince Pence to serve a different group. And then we have this case, the Cop City case, where the enterprise is alleged to be, it's very, very unclear from this indictment. I don't want you to think there's anything clear about this indictment, but essentially what it seems to be alleging is that there was a group called Defend the Atlanta Forest, which is not a corporation. It's not a business. It's not a partnership. It's not even clear that it's a group of people. But the allegation is that it's a group of people. That's the enterprise, and what we refer to sometimes as an association in fact. It's a group of people who have a common goal, and the common goal is to stop the building of the Cop City training facility and the destruction of the forest in DeKalb County. And again, so that's the enterprise, the group of people. The racketeering acts are various crimes, but I must tell you, this indictment, which is 109 pages, it doesn't allege specifically a single racketeering act, not one. This is a conspiracy case. It is a conspiracy to violate RICO, which it's really mind-boggling to try to imagine what this exactly means, but a conspiracy to violate RICO, and it is alleged that the group of people conspired to commit an assortment of crimes in order to stop the destruction of the forest and the building of the police training facility. But again, we've got 109 pages, and all it alleges are what we refer to as overt acts, which are aspects of a conspiracy, but never alleges a single racketeering act, not one in 109 pages. If you would do a word search in the computer, the word enterprise only shows up 5 times in 109 pages, and the word racketeering is only in the title. So if you're seriously asking me to explain this indictment to you, I'm going to utterly fail, because there are aspects of it that are absolutely unintelligible. It is not the typical Fulton County RICO indictment. There's a lawyer in Georgia who very often helps Fulton County DA's office with indictments. He has nothing to do with this one. In fact, the Fulton DA has nothing to do with this case. They have absolutely refused to have any involvement in it at all, as has the DeKalb County DA. It's being run entirely out of the Attorney General's office, which is unusual for a criminal case in Georgia. Very few cases are run out of the Attorney General's office. It's not like the Department of Justice in Washington that, is mostly criminal prosecutors. There's half a dozen prosecutors in the whole state who work for the Attorney General's office. So that's kind of the background of what we're dealing with here. We're dealing with an enterprise that's very amorphous and hard to understand. We're dealing with unidentified racketeering acts and overt acts, which deal with various protest activities and the expenditure of money to help some of the protesters eat, God forbid, or get bus fare or to be bailed out of jail.
Really appreciate that explanation, Don. I think you really encapsulate the feeling of a riddle within an enigma, within a conundrum that a lot of us have trying to read this indictment. The next question that I want to pose specifically to you, Stanley. You recently filed a pre-conviction habeas for your clients in DeKalb County who were facing domestic terrorism charges. You're challenging the domestic terrorism statute under the First Amendment. What are the broad First Amendment issues you see with this RICO indictment?
Well, we brought an action, and by the way, there's been a change today. We can talk about it a little bit later. We brought an action not just under the First Amendment, but under the Georgia state constitution. So you've got 2 major problems, just first beginning with the Georgia state constitution. You've got a procedural problem because the statute was passed in violation of the law that deals in Georgia with the passage of legislation. So you've got a procedural violation which says you don't even need to get to the substantive violations because they didn't follow the mandated constitutional process under the Georgia state constitution in order to bring around this particular domestic terrorism statute. Then you have clearly, in addition to the Georgia state constitution, you have the First Amendment. I've done First Amendment cases one way or another for 40 years. I've never seen a more miserable, childlike, stupid statute charging that deals with First Amendment implications than this. You've got, in addition to the procedural problem, you've got vagueness, you've got overbreadth, you've got a lack of notice as to the entity, as to the acts. You have a statute that is not content neutral. You have a statute that seems to swallow the Brandenburg test that says, it's the old saying, you can't shout falsely shout fire in a crowded movie theater. You've got intent and you've got imminence. This statute can indict 12 nuns sitting at a winery for domestic terrorism if they wanted to do it. It is absurd in its wording. It is absurd in its direction. And it got even crazier in terms of the Superior Court. We brought a Habe application, which is allowed for someone even on bail because it's a significant interruption with their liberty interest. A week after we filed the motion, the DeKalb County District Attorney says, I'm not handling this at all, any of these cases. A week later, the chief judge, who originally was assigned the habeas corpus, recused herself without saying why. 2 weeks later, the next judge recused themselves from our Habe application without saying why. The Attorney General's office has never answered our papers whatsoever. And the county attorney, acting on behalf of the sheriff's department, answered it like it was a car accident by simply saying, don't know enough about it to answer, don't know enough about it to answer. So basically, we've been sitting here for 6 months waiting for action to happen, and it didn't happen. And well, today it did happen, because today we have filed a complaint in the Northern District of Georgia under the First Amendment, seeking to have the domestic terrorism statute struck down as unconstitutional. There's something called the Younger Abstention Doctrine, which typically says you can't go into federal court while you have state charges pending, but there's something called the doctrine of futility. And that's basically where we've spent 6 months trying to get justice. We've gotten none. We've gotten no hearing. We've gotten no response. Our client has been indicted by the AG in Fulton County for a RICO violation. Meanwhile, we sent a demand that the domestic terrorism statute that's pending against Ariel in DeKalb County be dismissed. And once again, he's ignored us. So today we brought a complaint in the Northern District of Georgia seeking a mandamus to have the statute struck down on First Amendment grounds. There may be some technical procedural problems. We may have to refile it. But the bottom line is what the county has done, what the state has done, what the Superior Court has done is violated, has created an exception to the Younger Abstention Doctrine. And it's triggered the doctrine of futility. So I think we're going to get our day in court in the Northern District of Georgia, and we're cautiously optimistic. At the very least, the court will order the Superior Court in Fulton, in DeKalb County, to deal with this issue affirmatively, or perhaps the Supreme Court of Georgia, or strike down the statute statewide. Even though our client's not been indicted at this point, she was originally arrested for domestic terrorism, and it's just sitting there. It's not been indicted. No one's handling it, but yet it's hanging over her head with conditions of bail and bond. So that's where we're at now. Again, to recap, the domestic terrorism statute is something from Mars. I've not seen anything like this in its wording, in its reach. It gives no notice. It gives no direction whatsoever. A terrible statute.
Thank you, Stanley, for clarifying or attempting to clarify what it has been a really complicated table setting by the state in this situation, beginning with the passage of this law, which has its issues.
Thank you.
I'll flip the tables around real quickly and have a question for you, Devin. So how has RICO and similar prosecutions, how have they been used before in Georgia?
Yeah, thank you, Susie, for that question. So it's a really interesting effort in kind of time traveling. As you told folks during my introduction, I was a public defender in Fulton County, so the same county where this indictment has been brought. Was there for 12 years. Never came close to one at that point in time between 2010 and 2022 when I left the public defender's office. Of course, had heard and been around for the cases that Donna referenced earlier in terms of the AEPS prosecution and at the beginnings of what was the YSL RICO. What we have seen, I don't know, in the past 2 or 3 years, though, part of my job is keeping tabs on what's going on around the state. There has been a really intentional effort by prosecutors from North Georgia to Middle Georgia to South Georgia to include RICO charges in places where there's kind of this amorphous concept of conspiracy. Oftentimes we are seeing them included in cases where you would oftentimes see participation in street gang activity charges, such as you see in the YSL case. And in a lot of ways, they're used almost interchangeably. And I don't know if there was just some kind of really quote unquote amazing CLE that all the prosecutors in the state went to at the same time. But whatever that the case may be, there it tends to be kind of a concerted effort by all prosecutors to, in my opinion, weaponize this statute in a way that allows for them to make trial about more than the substantive acts that are being alleged. With all these cases, there are actual, not so much with the Cop City RICO, but with like the YSL case, there are alleged armed robberies and alleged murders and alleged drug sales that are said to be done in furtherance of the gang or in furtherance of the conspiracy. Those are things that by themselves, any prosecutor could, in a less complicated manner, pursue and have a trial on it at any point in time. Certainly a trial that doesn't last 9 months without a jury being selected. But instead, what we're seeing is that what appears to be the state attempting to pass the burden of proof that they say that they shoulder happily, but they are running from, and attempting to find a way to navigate around the rules of evidence in a way that allows for them to tell general narratives of badness, for lack of a better term, as opposed to actually producing evidence that proves up the substance of what is the alleged crime. And so I think it's just, I'll probably get around to a question about this later on. Is this a strategic tactic that is being used to create leverage where leverage otherwise would not exist? I think as what we've heard from Don and Stanley to this point, the intertwining of RICO charges and domestic terrorism charges, it's just really confusing. And I'm fearful that what the state wants to do is just confuse the hell out of potential jurors and just say, hey, you did this particular act, which likely is not even criminal, paying for people to eat or have bus fare. But by proving that that did happen, that jurors somehow become confused with that actually being criminal, when the nature of it is that it should not be. On that note, I would want to pass a question on to you, Mo, regarding movement repression. Just real simple. What is it and how is that implicated here in this RICO and the previous domestic terrorism charges?
Sure. Well, I guess I would say first, for everyone who's ever been involved in any social movement, and especially for those of you who are named in this RICO indictment, Mazel Tov, you are part of the long tradition of the state going to great lengths to silence and discredit you. And from the Palmer raids to COINTELPRO to this indictment, that is state repression. State repression is generally the use of the state's power to target, harass, punish, and undermine any activities, ideas, people, or groups perceived as being a threat to state power. And the state's perception of what is a threat to state power can be the result of actual conduct that people are actually engaging in, whether or not that conduct is lawful. And even if that conduct is protected by the Constitution. And the state's perception of threat to their own power can also be based on nothing more than an individual or group's perceived identity. So you don't have to be doing anything effective or anything at all to be subject to state repression. So some examples of this are when cops use mass arrest as a form of crowd control at protests, when the FBI was sending letters to different chapters of the Black Panther Party to stir up conflict. It's a good example of state repression. Stop and frisk, driving while Black and walking while trans, where law enforcement selectively invokes vague laws to target disfavored identity groups, state repression. the selective investigation and monitoring of political groups, the overcharging of activists. These are examples of state repression that are legible and visible and known to us. But state repression always exists, whether or not we can see it. And the goal of state repression really is to criminalize whole communities. And RICO was literally developed to do exactly that. So this is not the first time we've seen RICO used against people engaged in politically motivated conduct. And it's certainly not the first time, as you mentioned, like the YSL case and the sort of substitution of RICO charges for conspiracy or street gang involvement charges, is certainly the way that we see RICO used against communities, whether or not those communities are understood to be sort of political groups or political movements. The prosecutions themselves are politically motivated, right? And are the state repression of targeted identity groups. So, this is certainly not the first time we've seen RICO used in this way. It may be the most flagrantly abusive instance. As Don was saying, the indictment is a mess. But yeah, I think in the case of Cop City, the kind of state repression we're seeing, there's, I would say, a couple of things at play here. One is fundamentally law enforcement works really hard to feel embattled and has like no tolerance for criticism of themselves or their beloved institutions. And the other thing that I think is happening is that corporations have worked really hard to insulate themselves from criticism and have lobbied intensely to criminalize all manner of what would traditionally be understood as protest behavior, including everything from traditionally protected speech to making really petty things like criminal trespass or black faxing or phone campaigns into highly punishable offenses. And so, whereas the First Amendment protects the right to petition the government, as more and more traditional state functions are getting outsourced to corporations, the First Amendment maybe becomes less and less relevant. And in any case, the First Amendment doesn't immunize you from prosecution for unlawful conduct just because it's politically motivated, right? But that said, there's been, I think, some tolerance around protest activity. So like if you have a protest that's occupying a bank lobby in the context of protesting that bank's policies, that's, I think, understood generally, or has been understood as protest related behavior, and has more been treated along the lines of traditional First Amendment protected behavior. But I think all that corporate lobbying really paid off in Georgia and elsewhere, because now what we have is a domestic terrorism statute that can jackknife something like allegations that would barely make out criminal trespass into domestic terrorism allegations. And then to follow that up, we have a RICO statute where domestic terrorism allegations, including, I believe, correct me if I'm wrong, unindicted allegations of domestic terrorism, can form the predicate offense for RICO. And so, as I said, the sort of magical critical attribute that makes RICO such a dream for prosecutors is that the law does function to criminalize whole communities based on shared beliefs or shared values, even if there's no actual formal community, and even if no community-wide illegal behavior exists or is alleged. So I think that that domestic terrorism statute and Georgia's notoriously broad RICO statute are kind of neatly dovetailed to maximally damage really unremarkable protest behavior. And so it is a really stellar example of state repression right there.
Thank you so much to Devin, and thanks to all the panelists for this really amazing background. So again, my name is Azadeh Shahshahani, Legal and Advocacy Director with Project South. I'm one of the co-moderators for this webinar. And so for the second section of the webinar, we're going to shift to basically historical comparisons and international law implications. So I wanted to pose the first question to Stanley. So Stanley, you've represented a bunch of different folks involved in different social movements. How does this indictment parallel your work representing Palestinian activists charged with terrorism or material support for terrorism?
Well, you know, it's interesting because one of the reasons why the federal international terrorism statute has survived constitutional challenge is because implicit in it is notice. You have an entity, you have an organization that is designated by the Secretary of State as an FTO. Be it a movement, be it a state, be it an individual. You and I, anyone can go to a website and just pull up what an FTO is, who an FTO is, what a movement is, what a state is. It provides notice to someone who might want to involve themselves in activity, whether it be peaceful, whether it not be peaceful. It provides notice that if you move forward in certain respects with a movement, with a state, with an individual, it violates federal law. It is a statute that is passed, or it's basically an administrative procedure that is passed by the Secretary of State. However, in addition to you being notified by going to the site, you can challenge the designation by virtue of an administrative challenge to the State Department, or you can challenge it in court if you are an identified person. It provides notice. It designates what constitutes material support, although now it's basically just words and thought. It also provides notice about what can be done, for example, to get an OFAC license to deal with designated organizations. So when you talk about international persecution, while I'm not supporting the FTO designation at all, it provides certain types of protections that give notice, give an opportunity to challenge, give an opportunity to litigate, none of which is applied here under the Georgia statute or the domestic terrorism pushes within the United States. So you have a situation where I go to a demonstration. The fact that Homeland Security may say, quote, it's run by an extremist organization doesn't mean anything. It doesn't provide notice to me that I'm joining a movement, a person, an action that is designated as a domestic terrorist entity. It doesn't provide an opportunity for the organization or the person to challenge it. It doesn't provide a vehicle by which to move the parties not to proceed with it. And when you talk about the Palestinian example, it's classic because most of the FTO designations came out in the early days just before Hamas became a designated FTO. So you had a growing Palestinian resistance movement in the United States, fundraisers, speakers, efforts to support overseas activity, and suddenly the State Department comes up with a designation. Hamas is an FTO. Other support groups in the United States are FTOs. Individuals are FTOs. You then move on if you participate. And material support designates what the acts can or cannot be. However, there was this case, Humanitarian Law Project, which basically said, if you know someone who's an FTO, if you say hi to someone who's an FTO, if you shake their hand, it's a crime. It's material support of terrorism. For the first time, it ignored the Brandenburg test that said pure speech and pure association in and of itself was not criminal, and now said, for example, if you want to train people to be medics for an organization, or in the case of US v. Amin Ali, let's say in the 8th Circuit in Minnesota, where someone raised money to go to a refugee camp where she had come from in order to provide food. She's indicted for material support of terrorism, convicted, and gets a 20-year sentence. But again, when you're dealing with overseas activities, there are certain built-in vehicles which provide, in theory, checks and balances that are completely absent in the Georgia domestic terrorism statute, in the RICO statute, and in other efforts in the United States right now to go after groups and individuals for speech, assembly, and association. The linchpin of any criminal wrongdoing is supposed to be notice, is supposed to be an opportunity to challenge, is supposed to be advance opportunity to make decisions about what you wish to do or not. All of that is missing in Georgia. For as Mo said a few moments ago, the Georgia statute like most of the FTO designations, are politically rooted, are politically driven, are part of a police and military agenda. But at least with the international designations, there are certain controls that are built in that on occasion actually work, that are non-existent in Georgia and are non-existent in the other efforts in the United States to push domestic terrorism statutes, or here to use RICO as a subterfuge to get around an unconstitutional statute.
Okay, just a very quick follow-up. There's a question in the chat. Has anybody or any organization ever successfully and effectively challenged their FTO designation?
No. What they have been able to do is make applications to the Secretary of State over a period of time to provide additional information, to provide updates, to provide sort of a checklist of what they are, to educate, to undo the ignorance, and they have been removed. Years ago, I was asked by Al-Manar whether, when they were designated an FTO adjunct of Hezbollah, Al-Manar asked for my opinion about whether they should challenge the designation. And I suggested to them, and I've gotten a waiver from them over the years, they not do it for two reasons. Number one, it was going to be a perjury trap, because during the challenge process, there are depositions, you were asked questions, they draw you into it. And number two, with the internet coming alive, who needed it? So yes, there have been challenges. The real problem is not so much in the challenge of the designation. The real challenge has been in the challenge to material support prosecutions and convictions, which basically say speech, talk, paintball games, and a travel overseas just to speak to people and hear speeches constitutes material support.
Thank you. Thank you so much. And I'm sure we'll come back to this conversation during the follow-up conversation also. I would like to ask Mo, in terms of how does this indictment parallel your work at Standing Rock, also Occupy?
Sure. So I guess with Occupy, I think we saw very run-of-the-mill state repression, right? There was like surveillance, there were people doing undercover work. We saw a ton of mass arrests. We saw a lot of police violence. And that state repression was certainly in the service of corporations. But I feel like it was almost like intuitive or out of habit. Like the NYPD is very used to just protecting bank windows. And during Occupy, there were almost 2,000 arrests, maybe over 2,000 arrests. Most of those arrests resolved without convictions, and almost no actual jail sentences were imposed as a result of those more than 2,000 arrests. With Standing Rock, the coordination between law enforcement and corporations got way more intense, and the resources that were thrown at surveillance and counter movement work were like military level resources. The stakes were raised. In Standing Rock, I think we saw what I would call the collusion between not only all levels of law enforcement, meaning municipal, county, state, out-of-state law enforcement, and federal law enforcement. But we really, in Standing Rock, see the private security apparatus coming in and then directing all of those law enforcement efforts, steering the state's response at the explicit instruction of the energy companies. And there in Standing Rock, we had something around 900 cases, and there were some very serious federal cases. But again, with those state cases, something like more than 2/3 of them resolved with dismissals or deferred dismissals. Many of the ones that did go to trial were acquitted, were found not guilty or acquitted from the bench. There were, again, almost no actual jail sentences imposed as a consequence of Standing Rock arrests. So I would say, in this movement lawyer space, we're very used to seeing mass arrests with low-level charges. We're very equipped to deal with some more serious charges, And certainly more times than we can count, we have sort of been through the crucible of the sort of wholesale public criminalization of the perceived protester identity, right? As opposed to the policing of unlawful conduct. We have come to expect this. And frankly, these tactics on their own have been quite effective at redirecting attention away from movements, exacting a real cost from people who work with movements, and draining resources from movements. But with Atlanta, I would say what I have observed, what is happening there is the next step in this evolution, where the city is taking its cues directly from corporate interests. The police department and prosecutor don't seem to even need to enlist militarized private security, maybe because they're already so well funded, and also because they're so prepared to ratchet up the level of threatened punishment so high, and for conduct that reasonable people just would not have anticipated could have these kinds of consequences. So this is functioning as this unbelievable chilling mechanism. But I guess what I would like to return to and remind everybody of here is, you know, the difference in what is happening in Atlanta as opposed to what happened in Standing Rock or Occupy or during the Green Scare or to the BPP and BLA or to the labor movement or any of the other, right, movements that have been criminalized is, you know, the difference is one of degree and not kind. We are all part of a long history of resilient activists, resilient activism. And the other thing that I want to remind everyone is an indictment is not a conviction. Right? They tried it in DC with J20, and as the second part of that adage goes, they found out. So, you know, this is obviously very demoralizing. It's taking a toll on people. It's certainly chilling activity and support. But despite the efforts of both police and corporations to create laws that criminalize protest activity, so far, the courts have not all been all that willing to go along with this. So I think it would be a mistake to assume now that these prosecutions will have legs. And certainly I would say that like movement legal workers and lawyers all over the country and all your sort of ancestor defendants, like all the people who have faced this kind of repression before, we are all sharing resources. We're all talking to each other and working together to try to mitigate whatever harm this particular instance of repression can do to the movement to stop Cop City. So I would say just, you know, optimism is a real tool, and I would caution against despair.
So much. My last question is to Stanley. In terms of the international law obligations of the US, so do these indictments violate the United States' own obligations under international law, including international conventions to which the US is a signatory or which the US has ratified? And how do programs like GILI, which is based in Georgia, it's basically a police exchange program with repressive states such as Israel, which, as we know, is an occupying power and an apartheid state, affect the US's adherence to its obligations?
Let me begin by, you know, just as a follow-up to the question that was asked to me, because the minute I stopped, I recalled, yes, there was an organization that was declassified by the FTO, from the FTL list. It was MEK, a terrorist organization that was delisted, but it's fine because then it went to work for the US government, assassinating Iranian scientists in Iran, working on behalf of the United States and Israel. And that's the lead into this question. There are fundamental covenants under international law which demand, whether it's from United Nations, that demand that meetings, rallies, protests, demonstrations, speech must be protected. It's under the Universal Declaration of Human Rights. It's under the International Covenant on Civil and Political Rights, the Arab Charter, which violates some of its members, more particularly in the Gulf and in Egypt, the African Charter on Human Rights, the American Convention on Human Rights, the European Convention for Protection of Human Rights and Fundamental Freedoms. These are all guarantees that the US in general, and Georgia in particular, in this case, are thumbing their nose at. These are statutes internationally which say the right to protest, the right to speech, the right to assemble, the right to say no, the right to create friction, the right to challenge is all protected speech. The United States in activity is a signatory to most of these. But then we get into another issue with GILEE, the violations. And again, I'm not exalting the federal oversight over these international relationships. But one of the reasons why the generally exclusive jurisdiction for international connections is with the federal government is so that you don't end up having 50 different relationships with foreign countries. So what do we have in this particular situation? We have this arrangement between Georgia police, the Shin Bet of Israel, who knows who else they've got arrangements with right now at this point, that may very clearly violate MLAT agreements, the Mutual Legal Assistance Treaty, which says if you're going to exchange information, if you're going to help one another, if you're going to share information that may have been obtained through torture, through illegal search and seizure, there has to be a vehicle or a process by which you can challenge it. You don't have that here. You've got the Interpol Treaty. You've got the Rome Statute agreements, all of which are designed to bring some uniformity, even though there may be significant failure in the way countries interact with one another when it comes to policing and when it comes to international law or when it comes to protection of international law, all of which is being violated under this agreement with the Georgia police. You have violations perhaps of the Foreign Intelligence Surveillance Act. There's no doubt in my mind that the Israelis who are working with those in Atlanta, Georgia on this project and elsewhere in the United States are providing information, are getting information in violation of federal laws, federal statutes, and agreements. And again, I'm not exalting the federal rule as being exemplary, as being just, as being appropriate, but it is designed to try to keep a limit to individual state action. You have what may be the Arms Export Control Act, which is the agreement between the United States and Israel, where money is provided, but only provided if Israel is in conformity with international law in terms of human rights. We don't know what the Israeli military or the Israeli police are sharing or doing with information to Georgia or from Georgia. What we have also is perhaps the best example on a local level is the JTTF of 20 years ago, the nightmare of the Joint Terrorism Task Force. I handled many of those cases. That's where you have federal, at times international, state, and local police departments that have no expertise to speak of, no training to speak of, that just in the name of protection, in the name of the broader liberty, engage in setting up cases, engage in using confidential informants, engage in sting operations, which sent people to jail for decades who committed no crimes. So getting back to the fundamental question, what you've got here is an agreement between state police, state officers in Georgia, and foreign countries, an exchange of information, shared information, providing vehicles for training potentially, providing vehicles for other things such as torture, in violation of covenants that the United States is a party to. And meanwhile, the United States sits silent, and the Attorney General of Georgia just thinks that they are suddenly the Attorney General of the United States or the Secretary General. So this entire effort rubs up against the linchpin of, in theory, what's supposed to be some oversight, some accountability, and some limits on police and military discretion. It's another outrage, and it's another situation where Georgia in particular has politicized a statute in order to silence dissent, to punish demonstrators, and to send a message.
Thank you so much. So I think this is where Devin and I can ask some follow-up questions. Devin, do you want to start? And then I'll follow.
Yeah, so I kind of have a two-part question that I think is probably best handled by Mr. Samuel. You spoke generally at the beginning just about what is required or what the state needs to prove in terms of enterprises or racketeering and overt acts and those kind of things. But I also have a question that goes towards kind of the specific advantages that the state may be attempting to create for itself, you know, as they make the rules. They try to make it in a way that benefits them and allows them to win. And kind of a tag along question to that, throughout the course of the movement itself, during raids or arrests, we've very frequently seen media statements be released by the governor in conjunction with certain actions by the AG's office. What, if anything, does that tell us about what to expect from this case?
Well, let me start with the second question, because I think that's almost easier in a way. The fact that neither the DeKalb County District Attorney's Office nor the Fulton County District Attorney's Office want anything to do with this case, I mean, affirmatively refused to have anything to do with it, tells you just about everything you need to know about the genesis of this case. It's coming out of the Attorney General's office. The Attorney General is, trying to become the next governor. Kemp is, clearly supporting him. And it is a most unusual case that starts and will be prosecuted entirely by the Attorney General's office. There's not even an assistant DA who signed on to the indictment. There's not even a local prosecutor. So we have one assistant attorney general in a very small office in the Capitol who's bringing this case. So it's clearly a political case. It's a politically motivated case, which isn't to say that, that the case shouldn't be brought at all by anybody about anything. I mean, there's individual criminal acts which can be prosecuted, not with RICO and not, with such a broad brush as this one is being brought. So let me go to the first question, which is, what are the advantages that the prosecution has in a RICO case like this? The advantages, and one of the reasons why RICO was passed, was to enable the prosecutor, originally mob cases, the original mafia cases, and now gang cases, to put in one case a whole, a lot of people who maybe don't know each other, who aren't affiliated in any particular way, but all who have a common goal and achieve that goal through a variety of different crimes that generally couldn't be brought in one indictment. Sometimes even people from different states, sometimes, individual criminal acts that were years ago, many times criminal acts that occurred in different venues. So that's the real purpose of RICO. The legitimate purpose of RICO is to enable a prosecutor to bring all kinds of different crimes in one indictment. And you see that in the Trump case. You see that in the YSL case. APS was more of a concentrated, set of activities. And the YSL case is a much more concentrated group of people, albeit a very disparate set of crimes: drug dealing, murders, carjackings, prostitution, all kinds of things. But there are disadvantages to a prosecutor bringing a RICO case also. And some prosecutors have learned the lesson that it's too goddamn complicated, and juries may not understand it, in fact. And though, you can say, well, the jury will just do whatever the prosecutor says, I'm not sure that's true with a Fulton County jury. I'm not sure about that at all. They have created all these new elements that they're going to have to convince a jury of: the existence of the enterprise, the existence that all these people had common criminal goals. If they were just to, if they wanted to prosecute 3 people for burning a bulldozer, prosecute 3 people for burning a bulldozer. It's a very simple case, an almost unlosable case if they can prove, that it occurred. But instead, they've got this gigantic mess on their hands. Second of all, they're going to have to convince the Superior Court judge in Fulton County, who may not be a fan at all of the AG's office, what they're going to do with this case. This is 61 defendants. You can't try a case of 61 defendants. And if someone files what's known as a demand for trial, in Georgia, we have the right to insist on a trial if you're in Fulton County within 60 days. What are they going to do? What's the prosecutor going to do with 61 defendants? You can barely fit them in Mercedes-Benz Stadium. So it's hard to imagine what the AG's thought process is in bringing a case like this. He is going to have more problems as we go forward than I think he's really contemplating. He may think that 30, 40 of them will immediately plead guilty to a misdemeanor and get out of the case. I'm not sure that's true. I'm not sure that's true at all. And so eventually the assistant AG is going to have to convince a judge that this is a viable indictment, which I think is a substantially uphill battle. Got 50 pages in this indictment of the history of anarchism in America. It doesn't belong in an indictment. You know, someone said it's like a mediocre high school term paper. Yeah, and then there's no racketeering acts. How could you have a RICO case, even a conspiracy, which doesn't list any racketeering acts? Not one. So, you know, I think they're going to have a lot of, I say it's one AG, one assistant AG is going to have a lot of problems with the judge at the threshold. It's going to have a lot of problem if the 61 defendants all decide to go to trial. You know, we're going to have to find a venue somewhere. It's not going to be the Fulton County Courthouse. Trump's got that locked up, you know, as well as the YSL case. Yeah, it's a mess. It's a mess. So I don't think it's all to the advantage of the prosecutors. I don't think they've thought through this very well.
Very much agree. And I really appreciate the point you made about the fact that both the DeKalb and Fulton County District Attorneys have not wanted no parts of this. We all know how much Fonnie Willis loves a RICO case.
Yeah.
And but to say no to it says a great deal.
Yeah. Yeah.
Okay. Azadeh?
You all, thank you so much. So in terms of a follow-up point / question, just to follow up on what Stanley said in terms of a foreign terrorist organization and the only group that has ever been successful in delisting itself, the MEK, which is an Iranian opposition group. I put a link in the chat for folks who aren't familiar with what the MEK is. It's basically a cult. So folks can, I think by reading that Intercept article, get an idea of what a complete joke this foreign terrorist organization designation is, and it all depends on the politics obviously of the US government and what they see in their interest in terms of designating various groups and people as so-called terrorists or not at a given period. So I hope that as we all are fighting to shut down Cop City, we can also intensify our efforts towards supporting folks, a lot of times Palestinians or others who are being charged with with terrorism for really standing up for supporting the Palestinian cause or other social justice movements. And so in terms of my question to any of the panelists, and to follow up on most point in terms of optimism, can any of you all provide us an example of a case of success, successful campaign in any of these realms, in the that movement has been able to basically fight against state repression? And I guess I'll start myself. So in the city of Durán, so here in the South, after a years-long campaign led by Palestinian and Black folks and others, was able to finally eliminate the police exchange program with Israel. So I think that that case provides a really it's a great example of what we can be doing here in Atlanta and really across the country, because there's not one or two police exchange program. There's many of them across the country, so that we can really join forces together to try to end these programs as a first step. So I don't know if anybody would like to share another example of a successful of a movement success, really.
Well, can I just, it's difficult in the United States because I can't recall, and I've done a lot of so-called terrorism cases, real and mostly fake. I cannot recall a prosecution in the United States that is so dumb, that is so inanely brought. As Don said, that is garbage, built on smoke and mirrors. So when you're looking for a precedent to be prescient as to what's going to happen here, there's none that I can think of, because this is just an outrageous overreach by the Attorney General's office for political purposes. And while it's not sui generis in the sense of AGs seeking to silence people, universities, movements, groups domestically, I've not before seen a racketeering charge where my buying a cup of coffee for someone I just met at a training session to fix a broken leg becomes an act of racketeering. So it really is sui generis. And I think for that reason, Don is completely right. I think there's going to come a time, but that means we shouldn't be less vigilant, or we should just say, oh, don't worry about it. I think there's going to come a time where the AG's office will have maximized the political leverage they think they can get and understand they're way in over their head and have a wake-up call, I hope.
Anyone else would like to respond?
Yeah, I mean, as I said, I really want to remind people that when we see these charges, they typically do resolve without jail sentences. And I obviously cannot see the future. As I frequently remind my clients, I am a lawyer and not a wizard. But in my experience, what we have seen is that the charges typically resolve without the kinds of serious consequences that people initially fear. And, you know, I think Don's explanation of this particular indictment is cause for optimism. And the other thing that I want to remind everyone of is that we do know that collective defense strategy and joint defense are not simply buzzwords for movement solidarity, and they're not just good for movements. They are legally effective strategies. And so to the extent that people do engage in joint defense and collective negotiation, we do see really positive legal outcomes, not just movement outcomes. So I would just want to remind everyone that we do have good tools at our disposal, and solidarity is one of the best ones we have.
Can I just follow up on Mo's comment for a minute? I represented someone in the PayPal 14 in Northern California, and it was the first so-called hacking case in the United States, federal prosecution, where people were facing $1 billion, their arms were going to get cut off, and there was a big panic, and they, you know, we're coming for everyone, we're going to get everyone. And at the end of the day, after years worth of struggle, defendants ended up with misdemeanors, conditional discharges, and $5,600 in restitution. And I'm not, again, I don't want people to misconstrue this and say, there's nothing to worry about in Georgia, because as Mo said, there was a joint defense strategy, there were joint efforts, there were joint planning sessions. We collectively convinced the government the case was crap, it was overcharged, and it should go away, and it did. Now, I'm not saying that's going to necessarily happen here, but obviously one of the tools in criminal defense work in movement or political cases is working with one another to collectively put pressure on the AG and on prosecutors, keeping in mind that what's driving them here is politics. And Lord knows we're much better at politics than they are.
Hey, thank you for those follow-up questions, Azadeh and Devin. I'm going to now transition into asking some of the questions that were posed to us from the participants. And as you know, we had over 700 registrants, and so we received a lot of different questions. And so I've worked to consolidate them, the ones that are overlapping into categories, and I'm going to sort of like ask them, basically ask a few overlapping questions at a time, and offer it to one of the panelists, and then see if anybody else would like to weigh in. Before I begin, and particularly because we're sort of making some of these international connections, I wanted to bring into the room a recognition of another group of forest defenders facing state repression right now that I learned about yesterday. In the state of Orissa in India, there's a community of Adivasi leaders, indigenous leaders, and local Dalit communities who've been standing down a multinational mining company that has been seeking to illegally expand its mining on their lands, which include over 20 forest reserves. And the company is being supported by the right-wing Modi government. And in August, police and paramilitary forces brutally repressed peaceful protesters, detaining and torturing more than 20, and subsequently charging them with outrageous charges of terrorism and red tagging them as part of the Maoist uprisings. And I spoke with some of the comrades from Orissa yesterday who are seeking international support and solidarity. And I spoke about the connection to the Stop Cop City forest defenders movement. And so I just wanted to take this opportunity to mention this. And at some point, I'll share a couple of articles in the chat for those who might be interested in learning more. I think that what I'd like to do is follow up on this discussion that we just had on the joint defense strategies. There were several questions around this, including how are you handling making sure folks have separate representation as well as sharing information important to common theories of defense? Is there a history of joint defense strategies that you can talk about, or collaborative legal strategies among co-defendants facing RICO charges, or also being targeted under terrorism laws? And how are you handling making sure folks have, has there been any thought of comparing problems of Stop City defense to the defense of Disrupt J20 protesters? And I think a related question is that, is there a defense against what is clearly political prosecution? Is there a defense surrounding that framework? And maybe we can go back to Mo on some of these questions and then move it to a couple other panelists.
Sure. I am not actually admitted to practice in the state of Georgia, nor will I be. So I am not representing any of these folks, just to be quite clear. I think that there are people who are working on trying to organize joint defense. It has been made quite difficult because a lot of the people have no contact conditions on their bond. And I said in the chat, I'm very curious about whether that can be construed as a Sixth Amendment problem. I think that, I have done a lot of, I've tried to do some education of both defendants and attorneys about the legal efficacy of joint defense. I think there is a strong strain among criminal defense attorneys who maybe have been educated to believe that their job is, regardless of what their client wants, is to shield their client from criminal liability by any means necessary. And so there is a incorrect belief among some people that a joint defense agreement could be unethical or could be a per se conflict, right? That you would be failing to adequately advocate for your client if you were involved in a collective advocacy. This is absolutely not the case, but it is a strongly held belief among a certain group of people. And so I think between that issue, I think between the potentially there's a culture issue there, and between the fact that the defendants are being isolated from each other, it's been an uphill battle. But I do know that there are people all over the country who are really working to remind the people who have been indicted or the people who are facing charges that they steer the ship, that it is their right to decide how they want these cases to be fought, and that they have the authority and the expertise to advocate for themselves in their attorney-client relationships.
Thank you. Devin?
Thank you. So I think I'm probably really well situated to weigh in on this, being that my organization, the Southern Center for Human Rights, is the hub organization that is essentially helping to pair those persons charged with charging this indictment with counsel. So the first thing that I would say is that we are going through a vetting process. We have received numerous inquiries from a bunch of attorneys who have expressed interest in potentially representing accused persons. I will be just very clear, not everyone who has expressed a desire to be a part of direct representation is going to be allowed to directly represent people. We've already turned down a few folks. Some of it's based on the fact that they lack certain experience. We do ask a question about the willingness to participate in a joint defense agreement as a threshold assessment question. And we need for folks to at least be open to that possibility. Once the defendant meets their attorney, they are free to control that relationship in whatever way that they deem necessary. I think there was a question in terms of how are we facilitating the implementation of joint defense strategies. One of the things that we're attempting to do is build a database, a place for the attorneys to consult with one another in an organized structure, not just in email, not just in text. Those things can get really unseemly very quickly. We have taken a lot of advice and are continuing to recruit those attorneys who are not in the state of Georgia, who cannot practice in the state of Georgia, but who are willing to lend their expertise as it pertains to their prior experiences with defending RICO cases or defending domestic terrorism cases or First Amendment cases, and essentially creating a team of people who can contribute through research to aid those persons who are engaged in direct representation. We know that, again, with these RICO cases seemingly being just onerous time commitments, that the labor that goes along with it could be a deterrent for otherwise qualified attorneys. And so we're doing what we can to lessen the hold, the time restraints and labor intensiveness of the process for those attorneys to make sure they have what they need. We are, what else? It's so much that's going on. The public defender system in the state of Georgia is not built to handle a 61 co-defendant case. And so we are fundraising currently, trying to raise enough money that can pay attorneys competitively. I understand that there's probably not ever a number that's sufficient for what people could potentially be signing up for, but we are making sure to pay qualified people a better than kind of living wage to ensure that they have what they need to stay in the representation for as long as possible. We are being very intentional about not paying rates that would de-incentivize attorneys from zealous representation. We don't want people who are going to be inclined to lean on clients because they don't want to work on the case anymore. We want people who understand that when you get on this case, you are likely going to have someone who wants to take this to trial. And so we're not just looking for criminal defense attorneys or just First Amendment attorneys. We are looking for trial attorneys. We want to make sure that those people who are, fighting for their lives essentially, have someone who is willing to be in that fight with them. There are probably a couple other things that I'm not thinking of at this moment, but we are essentially creating a structure to anticipate future actions by the state. Oftentimes when we have these massive prosecutions in Georgia and elsewhere, well-meaning attorneys are scrambling to build an infrastructure. We know the game, we know the playbook now, and we are making sure that the defense bar is prepared and structured in a way to counter these type of actions in the future. And taking criticism and help wherever we can get it to sharpen our sword in a way that ensures that those folks who are accused know that we have their back. I think, was it Mo who said earlier, maybe someone else who was saying that optimism is probably one of our greatest tools at this point in time, and giving people a reason for optimism and hope is one of the greatest things we can do to let people know, like, it's okay. Fight as hard as you feel you need to fight. Don't feel pressured to concede to the efforts of the state.
Thank you, Devin. I think because it's already 8:20, I'm going to probably read out two other sort of categories of questions. But before I do that, for all of you to sort of answer before Sarina closes this out. Before I do that, is there anybody else that wanted to talk about sort of the usefulness or history of joint defense strategies, or the question about political sort of political repression defense strategies? Okay. So I know that, you know, we have heard about how, as some of you have said, you know, they're kind of in over their heads, and in their sort of zealous kind of like targeting and prosecution of these activists. But, you know, we do have a lot of non-lawyers in our audience, like activists and community members. And, you know, we received a number of questions that reflect, I think, a great concern about the, you know, long-term impact of these indictments and the potential of new indictments. And, you know, there was a specific question about if they wanted to put forth new indictments, if they would need to have another grand jury. But folks also ask questions about, you know, the potential of seeing sort of similar actions, similar indictments or prosecutions happening in other states, right? And another sort of, I think, important cluster of questions as well is that, well, what can we do, right? I think there was a question about how can out-of-state attorneys sort of like be helpful for all of you, number one. And there was a question about like, what can law students do remotely or virtually to also support what's going on? And, you know, and just how can we, like, I guess an added question to that would be then, like, you know, what else do we need to sort of do politically, you know, to simultaneous sort of like political work that supports kind of the legal defense, right? Especially in the ways that, you know, are sort of even kind of like movement ideals and values are being, you know, sort of are being criminalized and demonized, like anarchism, for example, right? So who'd like to start?
Could I shift to one issue, because I've seen a lot of emails about the future. I'll tell you what concerns me. I have colleagues and comrades and clients who were thrilled to see DOJ seeking 3A1.4 terrorism enhancements for January 6th. It's a terrible idea. They're terrible in international terrorism cases. They're terrible in domestic terrorism, so-called cases. And the reason why it's terrible is when you seek an enhancement after a conviction, it's no longer proof beyond a reasonable doubt, but it's up to a judge by a preponderance of the evidence to decide that such enhancement should happen. And in the context of 3A1.4, you add 12 levels to a terrorism conviction, and you move someone from a career criminal history 1 to a career criminal history 6. So a statutory cap that could be 10, 15, or 20 years with multiple convictions ends up being a 50-year sentence, and not because a jury has decided it, but because a judge has made a decision. So we have to be careful for what we ask. If it seems to me a state is looking for a terrorism enhancement, it should be a question established by beyond a reasonable doubt by a jury, and not a factor. So what can we do? We have to be careful about, well, it should be applied against them, because when it's applied against them, it's applied against us. So I think this whole terrorism speech enhancement, activity enhancement is something we have to be very careful about. And what I fear is not so much 50 states with domestic terrorism statutes, has 20 or 30, 40 states that empower judges on their own and by a preponderance of the evidence to enhance sentences well above and beyond the statutory maximum for what someone is convicted of.
Thank you, Stanley. Don, would you like to touch on any of these questions or any of the comments?
We're listening to the joint defense agreement discussion. Of course, we have a long tradition of having joint defense agreements in Georgia. There's no question about that. I don't think anybody considers them in Georgia to be unethical. In fact, it might be ineffective assistance to counsel not to consult with other lawyers and to prepare for trial and prepare a joint defense. I am very sensitive, though, to the autonomy of the individual clients. I sometimes get worried that lawyers are more interested in the joint defense than the client is on occasion. And I think that presents troubling ethical problems for lawyers. So, it's a balance. But I think in this case, fortunately, from what I understand, it's not going to be a very troubling problem because most of the people are very interested in a joint defense. Most of the defendants, there may be some, who are essentially college students somewhere who were here, weren't even part of the movement and just, kind of were along for the ride. And, I can imagine some are going to take a diversionary sentence or a misdemeanor, be on their way. But, the joint defense agreement is not just sharing information and sharing strategy, but, I mentioned that in Georgia, we can demand a trial and be in trial in 2 months. So if by October 30th, with this indictment, any number of people file a demand for trial, that joint agreement alone is going to put the prosecutor back on his heels. I'm mystified as to what he's going to do. One judge can't handle it. One prosecutor can't handle it. The 2 county DA's offices aren't interested. They're either going to have to start dismissing cases wholesale or, offer diversion or something that are, 20, 30, 40 people will accept. So, a joint defense agreement doesn't necessarily require anybody to sacrifice anything. It can be, 100% to the benefit of all the people without anybody having to sacrifice individual decision-making and individual thought about what's best for the individual client.
Azadeh, would you like to touch on any of these questions or comments yourself?
Well, at this point, I think everything that needs to be said has been said by the panelists, and I would just like to thank everyone for joining this conversation and encourage us to continue to see the connections between repression happening against folks doing movement work in this country and also globally, especially in the global South, and perhaps we can learn some strategies of resistance from folks in the global South with an eye towards optimism always. Thank you.
And okay, how about then the question of what can be done, what kind of support can law students, out-of-state attorneys, or even just activists sort of provide at this point? Devin, please.
Yeah, so I think I alluded to this earlier. We are working to create kind of a resource database of those willing to provide research and labor and able to connect them through the use of joint defense agreements with attorneys. So I would encourage anyone who may be able to research a little bit or research a lot to email bridge@schr.org. That's bridge like a physical bridge at schr.org. That is Southern Center for Human Rights. Currently, myself and one other person are manning that email, and we're getting dozens every day. So I'm asking folks just to exercise a bit of patience and grace as we work through that and try to give everybody substantive responses. You should get an automatic reply that gives a link for you to fill out an interest form that allows you to give us details about your history, your areas of practice, what you are able to provide. And that's the beginning step. And we will have, we're staffing up. We have a couple of hires we should hope to make in the next week or so. And yeah.
Thank you. And I wanted to just also repeat this question that perhaps somebody can help us close out on, anyone really. Just again, as to what are the implications for future Cop City protests, right, and other protests, and also how can we be ready?
Can I just briefly add one point? Someone
Sure.
asked a few moments ago, and it's connected to this, what can we do? And it has
Right.
to go with going forward. In political cases, I'm a strong believer, even though the judges, if they're experienced, will tell you you can't do it. I'm a big supporter of jury nullification. You've got an indictment that reads like J. Edgar Hoover chasing Emma Goldman 100 years ago, but crap. It's important, just as we are going to have to educate jurors about the politics of this case and focus on what did happen and did not happen. As long as the community out there keeps the pressure on, educates the community, builds coalitions, those jurors that we're going to select from is going to be filled with people that are going to have open arms and open hearts. It may just accept the jury nullification argument, which I've been able to do successfully in some political cases. Education, education, education.
And money.
Yeah, well, that too.
And someone put in the chat, and I'll just raise and lift this. In order to make sure that attorneys are paid and that kind of thing, there's a link that has been posted a couple times in the chat, https://secure.actblue.com/donate/ATL legal fund. Atara, I think if you could post that again, just so everyone's attention is to it, share it repeatedly on your social media every day, make it a habit. Yeah, the sooner we can let these attorneys know, like, yeah, we can fund you all the way through trial, the sooner that we can explore these really direct actions that Mr. Samuel is pondering in terms of the possibility of filing speedies and that kind of thing.
Thank you.
You mean
Thank
I'm
you
not
both.
going to have to hitchhike from New York? Hopefully.
Okay. I'm going to then transition back to Sarina.
I think it's to Susi.
Oh, please, Susi, go ahead.
All right, well, it's the end of the panel. I just want to remind folks, these indictments are intended to serve a political end. No matter what the governor says, no matter what the mayor says, the attorney general says, is to silence the protest movement, to prevent it from having access to attorneys, bail support, and even legal observation. And I'd be remiss not to say or to note that among the 61 being charged include people arrested for handing out flyers, for serving as legal observers, for providing bail support, and for fundraising for the campaign. Specifically, 2 of our own National Lawyers Guild members, a local member who was arrested for being a legal observer, and a law student in UNC Chapel Hill, Jamie, who was also swept up in these arrests. So I wanted to make sure to mention them. And just, Atlanta, we remain unintimidated and undeterred. And as Mo said, solidarity is the best tool we have at our disposal. Remain optimistic. Their intent is to repress the movement, is to discourage us, and let us not be discouraged. I really want to mention this recording will be available on the website. So yes, we will have this available. And thank you to our moderators, Azadeh and Devin. Thank you so much for taking time out of your day today and for providing your expertise and for moderating the panel. Thank you to Don, Stanley, and Mo for your expertise, your work, your history, just your experience, and just having been there for 20, 30, 40 years, as mentioned in your bios. Thank you to our president, Suzanne, for joining as a co-host, and to Joelle, our interim executive director, for your support. I want to thank Sarina for organizing this panel and for your endless support to the Atlanta chapter. I want to thank Charlotte for the logistics, is behind the scenes, making sure the Zoom studio doesn't fall, and also for helping organize this panel. So as mentioned before, there are several ways to plug in. The Southern Center for Human Rights Bridge email has been shared in the chat. You can also donate at the link that's been shared there. This will also be included in the once this goes online. With the local Atlanta chapter, if you want to support increasing our legal observer capacity so we can provide support to local movements in Atlanta, you can join. It's nlg.org/join. You can also join Project South as a member or donate to their work. I will post the link in the chat. And finally, one of the best ways to support the movement is to not be discouraged. Let us not forget about Tortuguita. Let us find support and care and encouragement with one another. Again, I want to thank you everyone, panelists, moderators, co-hosts, and everyone who joined us on a Monday night or Monday afternoon if you're somewhere on the other side of the country. Otherwise, thank you all so much. I really appreciate it.
Thank you for inviting me.